As the custos appointed by the Faculty of Law, I declare this public examination of Veerle Platvoet, doctoral dissertation open. The title of the dissertation is Unearthing Wild Animal Law, a theory on the foundations of the European regime for wild animals. The opponent is Professor Werner Scholz from the University of Southampton.
Thank you. Honored custos, honored opponents, members of the audience. At some point during the third year of my PhD, I was in the Netherlands on a research visit. Contrary to here in Helsinki, the Netherlands allows dogs to be off-leash in certain unfenced areas. Also contrary to my life in Helsinki, being back in my home country meant I could not escape small talk with strangers easily. As I was walking Elvis, my dog, in one of these unleashed areas, a woman stopped me to chat because my dog reminded me of a dog that she used to have. She told me that she used to love having her dog off-leash, even though it was not without incidents, as her dog, like mine, was a hunting dog. One time, she said, she was devastated when her dog caught and killed a rabbit. But, she continued, she then saw that there were many rabbits in that area, so she did not feel as bad. I did not bother to go more in-depth about her change of feelings, but I did find it very interesting, and, little did she know, her change in sentiment concerns one of the main themes of my PhD. We care greatly about our dogs as individual beings, so we let them off-leash, even though there is a risk that our dogs kill a rabbit. Clearly, the life of the rabbit is not as important as the freedom to run for our dogs. And the morality regarding the death of an individual rabbit becomes negligible when we see that there are many individuals of that species. Would this woman have witnessed her dog killing an individual of the critically endangered wild European hamster, her sentiment might have remained one of sadness. When it comes to wild animals, their abundance as species seems to be directly related to our care for their survival as individuals. What is the ethical framework surrounding this? Are these moralities reflected in the law? How does their abundance relate to their legal status, and what does that mean? Is there a way to look beyond the numbers in law? And if so, how? These are questions I try to answer in my PhD thesis. Or, to put it more comprehensively, I try to examine whether wild animal law is an area of law, and, if so, what its unifying foundations are. Before I get further into the main themes of my thesis, let me clarify that with wild animals, I refer to all animals that are not under human control or supervision. The reason that I initially wanted to examine this question is the view reflected in most of legal scholarship on this topic, which states that there is a dichotomy between animal law and environmental conservation law. I refer to this view as the orthodox view. The orthodox view can be characterized by the three following interrelated premises. First, the assumption that animal law and conservation law are built upon conflicting ethics. Second, that animal law and conservation law have irreconcilable foci points, these being the individualism of animal law and the holistic view of conservation law that aims to protect biodiversity. Third, that, as a result of these foci points, conservation law lacks any regard for the welfare of animals, unlike animal law. Common perceptions within the orthodox view include, therefore, that conservation law and animal law might seem similar to an outsider, but that an insider knows that they are incompatible due to the value that conservation law assigns to holistic systems or species and the value that animal law assigns to individual animals, regardless of their species. My research, therefore, aimed to analyze conservation law and the extent of animal welfare provisions within it, in order to clarify whether the orthodox view is accurate or not. For this, I used the method of the reflective equilibrium, albeit a slightly modified version. In my version, I assumed an understanding of the law from a moral perspective, and that, therefore, an ethics-based analysis of the law could unearth the moral underpinnings of said law. With this assumption in mind, the use of the method was as follows. I analyzed laws to infer the legal rules and legal principles, and aimed to find coherence between these rules and principles and the justificatory background theories, which were derived from ethics. The law that was analyzed was international and European conservation law, policies, and judgments, as well as animal welfare provisions that pertain to wild animals from a variety of legal instruments. The justificatory theories were theories in animal and environmental ethics. Using the reflective equilibrium, I found that the justificatory background theories of rules and principles regarding animal welfare and animal conservation are compatible. I also found that conservation law reflects legal rules and legal principles regarding wild animal welfare, thereby not necessarily maintaining a holistic focus point regarding the protection of biodiversity. These animal welfare provisions in conservation law, as well as in instruments from other domains such as animal health, moreover confirmed a regard of animal welfare in conservation law. In other words, my analysis challenged the three premises of the orthodox view. This exercise also allowed me to distinguish the general legal principles of what I then went on to call wild animal law, which supports its inauguration and ultimately its establishment as an area of law. So what are the legal rules, legal principles, and justificatory theories of wild animal law, the lega lata, or the existing law? I first go through the equilibrium regarding rules that relate to the conservation of wild animals, and second, through the equilibrium regarding rules that relate to the welfare of wild animals. Regarding conservation, for the purposes of my research, I found the following legal rules to be important. First, the rules pertaining to listing certain species under conservation law instruments, so that the obligations that can be derived from these instruments apply to the listed species. And second, the ability to derogate from these obligations. Often, these lists include animal species that need to be protected, such as in the case of the European Union Habitats or Birds directives. But this is not always the case. The EU Invasive Alien Species Regulation, for instance, concerns obligations regarding a list of animal species that impose a threat to the environment, and their spread needs to be contained. The obligations regarding listed species for protection were quite substantive, relating to prohibitions to disturb, capture, or kill animals. However, each of these obligations were in principle open to derogations. These derogations, or exceptions to the obligations, can be applied in a number of circumstances, such as the protection of human health or safety. In addition to these circumstances, two other requirements have to be met. There must be no satisfactory alternative, and the derogation must not be detrimental to the favorable conservation status. The latter being here arguably the most significant. If a species is deemed to have an unfavorable conservation status, the odds of a derogation that is further detrimental to the status is unlikely to pass. Conversely, if the conservation status is favorable, derogations are applied far more easily. These rules bring me to the overarching principle that can be derived from these rules and from the regime itself. Hence, the first principle of wild animal law is the goal to maintain biodiversity in order to sustainably use it. In other words, the law aims to ensure that biodiversity can be used, but that this is done in a sustainable way to ensure the continued use of biodiversity for future generations. Therefore, the more endangered a species, the more strictly it will be protected, until it is no longer endangered. I will elaborate on the relation between rare species and biodiversity more later. Considering the justificatory background theory, I encountered my first incoherence. The legal principle is thus focused on the human use of biodiversity, barred by the limits of sustainability. But the law, instruments such as the Convention on Biological Diversity or the Council of Europe's Berne Convention on the Conservation of European Wildlife and Natural Habitats, recognize the intrinsic value of biodiversity, or in the case of the Berne Convention, the intrinsic value of wild flora and fauna. And intrinsic value, as environmental ethicists and environmental lawyers are quick to point out, is the objective value of an entity, which is unrelated to whatever use humans might have for it. However, this idea of intrinsic value of biodiversity does not align with the legal principle I just laid out, maintaining biodiversity for the purpose of its sustainable use by humans. In this principle, the human-centeredness is clear. In other words, the justificatory theory and the legal principle are incoherent. So, in order to find coherence, I considered other ethical theories on the matter. I found a subset of environmental ethics called prudential anthropocentrism, which is the view that all moral duties that we have towards the environment are derived from direct duties to its human inhabitants, and a subset thereof called cynical anthropocentrism, that we have a higher level anthropocentric reason to be non-anthropocentric in our day-to-day thinking. These theories are not very popular among environmental ethicists because they admit that the notion of intrinsic value of biodiversity actually is related to human values. But I do think prudent, or even cynical, anthropocentrism is coherent with the legal rules and legal principles surrounding animal conservation. For the second equilibrium, I started with the legal rules relating to the welfare of wild animals. Remember, the orthodox view stated that conservation law does not consider animal welfare. However, I did find rules related to wild animal welfare, spread across a variety of legal instruments, including conservation laws, animal welfare laws, animal health laws, and the semi-constitutional law of the EU, as well as judgments from the Court of Justice of the EU and the European Court of Human Rights. For instance, conservation laws prohibit the use of certain hunting methods or techniques, not because these are indiscriminate and could therefore affect conservation, but because they cause harm to the hunted animal. The Invasive Alien Species Regulation, mentioned earlier as the regulation that aims to prevent the introduction, establishment, and spread of species that harm the environment, contains provisions on how, when the invasive species is an animal species, any measures undertaken need to spare them from avoidable suffering. Similar provisions were found in legal instruments and judgments across the regime. Such provisions, I gather, are animal welfare provisions, regardless of whether they are found in a legal instrument with a conservation or animal health objective. The underlying principle of these rules, and thus the second general legal principle of wild animal law, is, I contend, safeguarding animal welfare through the prohibition on unnecessary suffering. I will elaborate more on this relation between animal welfare and this prohibition later. The prohibition on unnecessary suffering, or anti-cruelty, can be found either directly or indirectly in the legal rules regarding wild animal welfare. Anti-cruelty is a negative obligation. It's an obligation to refrain from a certain behavior. The positive obligation side of the animal welfare coin are legal obligations regarding humane treatment, with legal rules on the provision of water or shelter, for instance. Such rules and the principle of humane treatment do not apply to wild animals, to whom we do not share the same responsibilities as the animals that we keep. Anti-cruelty, however, applies to all animals, including wild animals. The justificatory theory here is, again, not found in mainstream animal ethics. Utilitarian animal ethics do consider the minimizing of suffering, but the element of necessity is not as prominently present as in the legal principle. Welfarism and the interest convergence theory, however, are more coherent with the legal rules and principles set out thus far. Welfarism is a description of the current legal system and its treatment of animals, which can be summarized as the designation of animals as property in order to justify animal treatment as a means to human ends. This use, under the welfarist logic, only is considered necessary when part of an accepted social institution, and as such, animal cruelty is not understood in the same way as in ordinary discourse. Although traditional legal welfarism focuses largely on the property status, which is not applicable in the same ways to wild animals, the notion of suffering being deemed necessary in animal exploitation that is accepted, and the notion of cruelty not being the same as in ordinary discourse, are still very applicable. However, the cruelty that can be done to wild animals is not always the same, and rare animals can be protected against cruelty, meaning the theory of welfarism requires some nuance. The interest convergence theory provides this nuance. This theory describes how animal interests are protected the more they converge with human interests, and vice versa. Therefore, legal welfarism explains why unnecessary suffering is a principle of wild animal law, and the interest convergence theory explains why a higher threshold of suffering is permitted or deemed necessary towards unprotected or unwanted animals than to protected animals. Protected animals, after all, have interests that align with the human interest in biodiversity. So, we now invert a number of legal rules for wild animal instruments to arrive at the legal principle of maintaining biodiversity in order to sustainably use it, and the legal principle of the prohibition of unnecessary suffering. Note that these two principles are by no means incompatible. The justificatory theories are prudent anthropocentrism and welfarism, complemented with the interest convergence theory. These ethics all have the dominance of human interests in common. The human interests decide whether and how to protect animal interests, thereby subordinating these interests. The fact that certain wild animals that belong to protected species are very well protected under the regime does not undermine this facet. It simply means that the interests of these animals converge with the human interests. Similar to the legal principles, these justificatory theories are compatible. Now, you might recall that I promised to elaborate on two specific relations, between biodiversity and rare species, and between animal welfare and the prohibition on unnecessary suffering. The way these relations have established itself in the law are what I call the biodiversity and welfare dogmas, and they form the implicit foundations of wild animal law. The biodiversity dogma reflects an inconsistency between biodiversity as a concept, which can be made operational through measurable methods and as such is grounded in conservation sciences, and the value-laden biodiversity that presents itself in conservation law through the species rarity surrogate, which is the way conservation law instruments protect biodiversity. In other words, although conservation law might appear to protect biodiversity as a whole, it actually simply protects a few selected species that are listed, thereby legitimizing the exploitation of all other species, including species that might contribute to ecosystem health or overall species diversity in an area. The welfare dogma, similarly, concerns an inconsistency between the notion of animal welfare, including its closely linked notion of suffering, both of which are measurable and as such grounded in animal welfare sciences, and the value-laden idea of animal welfare, and especially unnecessary suffering in the law, which protects animal welfare only insofar as it converges with human interests. Again, animal welfare law might appear to protect animal welfare. It actually legitimizes the exploitation of animals. These dogmas and their subordination of animal interests to human interests I found to be deeply problematic. Therefore, in the final part of my PhD, I undertook an exercise of reimagining, to rethink legal rules and legal principles based on a justificatory theory that rejects animal subordination. Hence, I again used the reflective equilibrium, but this time reversed the layers and aimed to find legal rules and principles that are coherent with a justificatory theory that has the potential to rethink wild animal law. I found such a theory in critical animal studies. The three relevant elements of this theory that I used to build my legal rules and legal principles upon are as follows: the recognition of animal subjectivity, the importance of relations, and the rejection of human domination over animal interests. These elements created the animal-centric framework. In order to find coherence, I then tested two normative proposals in animal law scholarship. The first is the relatively common normative proposal to give animals legal rights. For a variety of reasons, I found these theories to be insufficiently coherent with the animal-centric framework. Then I turned to the emerging idea to protect animal agency in the law. Here I found more coherence between the animal-centric framework and the legal framework of agency, which consists of freedom-based autonomy, relational autonomy, the capabilities approach, and the capacity of self-determination as theoretical scaffolding. The legal principles I devised on this basis were to promote flourishing, to protect animal communities, and to ensure coexistence. Using these principles and the framework of animal agency, I worked through 3 conceptual case studies to consider the legal rules in specific matters. These case studies were on wildlife management, wildlife conservation, and wildlife restoration. Ultimately, I hope that this contribution to the inauguration of wild animal law as an area of law can foster a bridge between animal lawyers and scholars and conservation lawyers and scholars. I believe collaborative efforts between the two could provide more exercises of rethinking and reimagining wild animal law, creating a lawscape that is built on compassion and coexistence of dogs, rabbits, European wild hamsters, and all other animals. Honored opponent, I now call upon you to present your critical comments on my dissertation.
Madam Candidate, thank you for that exposition. I was actually intrigued when I received your dissertation yesterday and when I reflected on the cover of the book. I noticed, I don't know if you've seen this, but there's a mole on the cover of this book, and a mole unearthing something, as you've said, digging. And when I considered this image, I was actually considering the fact that moles use these powerful, these spade-like paws, which they have. And what they do essentially is they dig tunnel systems. And through that digging tunnel systems, they create habitats. And that's quite sort of an apt image for this book, I think. So very, very apt in terms of the image that you've used there, in terms of the content of the book. And I'll reflect on this even further. Recently, the IPBES Global Assessment Report reflected the fact that about 1 million plants and animal species are due for extinction. And that extinction is something that will have a detrimental impact on the planet, on the ecosystem, humans, and all animals. And there are certain drivers for the extinction, such as climate change and pollution and habitat encroachment. But there's also, in addition to these direct forms of direct causes, we have an indirect cause mentioned explicitly in the IPBES, and that is a disconnect between people and nature, which I find quite interesting in terms of the topic that you've chosen to read. Because without transformative changes, and that is also explicitly made clear in this IPBES Global Assessment Report, without that real transformation, this situation or these trends will continue. And it will mean that the habitat will suffer and that humans will suffer as well as animals. And it's in this context that I actually read your contribution in terms of your research. I think we as lawyers, we clearly have an obligation to dig for solutions like a mole, unearthing, in order to create those tunnel systems to facilitate habitats. So it's about paradigm shifts and transformation. And I think when I read the book, I noticed that this was sort of an attempt, essentially, to respond to these challenges that we are facing in a modern environment by presenting a critical analysis and a theory on the foundations underlying the regulation of wild animals. So it's a profound analysis and sort of a digging, as I've said, in terms of these underlying theories, but also in terms of not only the positive law that the legalata, which you've referred to, but also the views and assessments and appraisals of scholars in this regard. And I think in this instance, through the research that you've done, Madam Candidate, you've also challenged certain truisms concerning the nexus between conservation and welfare provisions concerning wild animals in a very bold manner. But you've not only sort of challenged those premises underlying the relationship, you've also questioned the orthodox view which you've referred to in order to unearth some new habitats or some new tunnel systems, and then to inaugurate what you've referred to the proposal to create so-called wild animal law. And I think this thesis constitutes a very interesting legal analysis in the context of these relationships and in terms of law, but not only in terms of law, so the law pertaining to wealth and conservation, but also in relation to the underlying ethics, the theoretical foundations of that relationship, which makes it quite interesting. And as such, I think it is indeed an attempt to create that sort of transformative paradigm shift concerning the foundations of a profound issue which we face in this current environment. in the modern world. And I think in this regard, it constitutes to burgeoning scholarship concerning the relationship between welfare and the issue of conservation. And in that regard, I think it's based on a very comprehensive and analysis of the relationship between ethics and conservation. And just to conclude in terms of my initial statement, it is within this context that I, with considerable interest, reviewed and read your digging for a new habitat. And I look forward to engaging in further discussions today concerning a number of issues that I've read in terms of your theory on wild animals. Thank you. And so with that introduction and without further ado, as I said, I've read this with quite some interest, and I have a few questions pertaining to the content of the thesis. And the way in which we'll approach this is to first sort of question or pose questions concerning the premises underlying your theory. That would be the first part, sort of a more generic approach. And the second part would then be to focus on detailed aspects contained in the thesis. So first of all, you've provided a very good summation of the tenets of the thesis. I think the first question that I do have is concerning the orthodox view. And I will just refer to, I'm working on a remarkable, so if I'm a bit, sort of working in a slow manner, please excuse me. So on page 2, you refer to the orthodox view. And so my first question, and this is really important because the orthodox view that you sketch constitutes the point of departure for the exposition that follows. And it's through the identification of that orthodox view that you then refer to the two dogmas. And so and you do this in a very structured manner. And on the next page, page 3, you then refer to the three premises of the orthodox view. And I have a question concerning the premises as well as the point of departure. Now, my first question is, when you consider the orthodox view, my understanding was that essentially from the dissertation is that, and that's also read with the dogmas, because dogmas are beliefs. They are believed and not necessarily the status quo or the facts of a matter. And so the first question is, the point of departure is essentially that scholars hold it in an orthodox view, and there's a disconnect with the law as it stands. And so in order to address that, you then refer to the two beliefs or the two dogmas in terms of biodiversity and welfare, and later on in terms of the cases that you've discussed with a point of departure of European regime, especially with a reference to Article 13 as an objective. And so my first question is, do you think that it's correct, essentially, to refer to the orthodox views of scholars? Is that not dangerous in the sense that it could result in a situation whereby there's a misidentification of the issue? Because essentially the scholars, well, various scholars have referred to the situation in terms of law as the orthodox or traditional dogma, or doctrine, not dogma, in terms of the fact that there is a divide in terms of the regulatory normative frameworks on a global level, so both international wildlife law as well as in terms of domestic jurisdictions, concerning a scant regulatory framework for wild animals. So there's a near absence in terms of law. And then scholars actually use that as a point of departure, and this differs from your point of departure, that as a point of departure after that identification in order then to sort of advocate for changes on the basis of the fact that that disconnect is incorrect and inconceivable. And so my first question is, do you think that it's indeed correct to use that sort of description of scholars as the orthodox view, as a point of departure for the discussion that follows, with specific reference to the evidence given in terms of the normative framework, in the European framework.
Right, thank you. I would say, indeed, I also started from this divide in regulatory frameworks, as you mentioned. Also in my previous work for the government, I noticed that there's these two different silos between conservation and animal welfare law and policy. So this divide is real in that sense, and it's witnessed. So that was also the starting point of my PhD at first, that there is a divide, and then I wanted to research how to improve it. But then as I started my literature review, I also noticed that often scholars would refer to this divide or this dichotomy between animal conservation and animal welfare, and then reference ethical works, actually. So, for instance, the seminal article from J.P.R. Callicutt on a triangular affair that every wildlife lawyer is familiar with. So these kind of conflicts between, like the works on the ethical conflicts between conservation and welfare would be referenced in order to like solidify the divide between conservation and welfare in the law as well. So from that like point onwards, I then started to think whether the law is indeed built on these like similar ethical conflicts that are apparently like so prominent in environmental ethics. So in that sense, I think my departure point was already different because I started to look at the moral underpinnings of the law that led to scholarship stating these differences. So in that sense, I think it is kind of accurate to kind of change this departure point and then start analyzing the law accurately. Because in that sense, if we know whether these ethical underpinnings are real or are different than what is usually cited, then I think it's much more comprehensive or like constructive to move forward, to deconstruct then the concepts and the assumptions that exist in scholarship. And then it's more a better opportunity arises, I would say, to then also start building these bridges between these two regulatory frameworks. Thanks.
Thank you, Madam Candidate. I'll just want to follow up in terms of that question with the three premises of the orthodox view, if you don't mind. And as I've mentioned them, the one is the conservation law and animal law are grounded in incompatible ethical approaches. And so if one takes cognizance of the two elements of intrinsic value of so-called biological resources, or what we refer to as animals, both as species and the constitutive components of the individual animals. If one takes cognizance of that point of departure, then clearly it's not, I don't think that one could then argue that the orthodox view is indeed based on a premise of incompatibility between those approaches. And you've referred to Beard Callicutt. So he's written, I think, was the 3 publications that followed in progression, whereby I referred to the divorce. But you could see the progression also in terms of his writings, where he moved towards reconciliation. And so I think what we've also noticed, that sort of stark dichotomy between the ethical approaches, have also changed to a situation so that I think it would be difficult to argue today that there is still a very stark dichotomy between the two. And this is reflected, I think, in the works of modern exponents of animal and environmental ethics. So that I wonder whether that is indeed a premise that holds water in terms of the orthodox view.
Yeah, thank you. Right, indeed, I think there has been this kind of body of scholarship referring to all these kind of different affairs or marriages or divorces of environmental ethics and animal ethics. And I think these works, they ultimately try to reconcile using often indeed intrinsic value, such as that there's these 2 elements of intrinsic value, like the species element and the individual element. But I do think, and I also argue in the thesis, that there is a conflation happening when the intrinsic value of the environment, for instance, is used as an argument to say that the environment has objective value, and this also applies to the intrinsic value of species, for instance, or like a good of its kind of intrinsic value. And for that, I also work or like build on the work of other philosophers that have done so. So I think because of these conflations, or in spite, I should say, of these conflations, environmental ethicists are still trying to argue for the objective value of the environment, and thereby also then trying to reconcile animal ethics and environmental ethics. But there's always, I think, something missing, because the objective intrinsic value of the environment, and especially as it then seeps through into environmental law or conservation law, it's very difficult to prove. Like, it remains subjective ultimately. So I think due to these conflations that are still very, very present in environmental ethics, there are still inaccuracies, I would say, in the scholarship on ethics that has followed from it, and also the legal scholarship that builds on these works.
Thank you for that response. Just also on page 2, you refer specifically to the dichotomy between wild and captive animals, and so that's also a point of departure, and you've referred to your definition of wild animals, and with a specific reference to ownership. So it's that control over animals which actually defines wild animals for you. Do you think that is maybe not problematic in terms of I would say the difficulty in terms of defining wild animals in the current context of the Anthropocene, where we know that as humans we dominate all aspects of this planet, and we've encroached upon habitat, and that in essence the really concrete cases, the acute cases concerning wild animal welfare frequently pertains to what is referred to as captive animals. Now, there are different forms of captive animals. You have ranch animals, for instance, and in those instances, domestic jurisdiction or domestic welfare legislation does not always pertain to those animals. A good example would be an example in South Africa concerning so-called canned lion hunting is a good example, where you have that blur concerning the issues of ownership. And so in the current context, what we've noticed also in terms of Anthropocene is a move towards ex situ conservation measures, which I personally find problematic, but that's a different matter altogether. And so when we move towards ex situ conservation, I think that blur becomes even more problematic. And so my concern is that in terms of a very stark definition pertaining to ownership, that could actually erode the protection in an ethical manner of wild animals. So I was just wondering whether that definition is maybe not too rigid in order to apply to the current circumstance and context that we are facing.
Right, thank you. Yeah, so I think indeed there's two different questions here. Maybe the one about like whether the Anthropocene still has such a thing as a wild animal that is not under human control or supervision. And then secondly, whether, like, what about these blurred instances like canned hunting, like these ranches with animals? And I think with regards to the first question, that is, of course, to a certain extent true. I think the Anthropocene has an effect on all habitats globally, and therefore also on the lives of wild animals. I think it's still useful, though, to have a distinction between the animals that we keep, that are under our care and that we have certain responsibilities towards, and the animals that are living in the wild. I think we cannot say that even though we've affected their lives, that they're therefore, like, to the same extent under our control and supervision as our pets or our livestock, etc., etc. So I think there's still a distinction there to be made, even though, of course, it should be acknowledged that the lives of wild animals are all affected due to our actions as, like, humanity. And then second, I absolutely agree that I don't think any binary is maybe ever completely separate. And also between captive and wild animals, there's a gray zone in between. There's many different instances. I also discussed in the thesis the example of rewilding with a case study of the Netherlands, where the animals are moving, you could say, from the captive side of the binary to the wild side. And it's very unclear what laws and regulations apply to them as they're in this gray zone. So ultimately, I suggest that this is always up to the jurisdiction to create maybe a definition of a wild animal and then also see whether these instances apply or not. So in this case of South Africa, I would also say that it's up to the jurisdiction there to qualify whether these are wild animals or not, and also why. Or maybe even come up with a third category that's like in between these two, and what laws would apply there.
Thank you. Would it not be more sensible and appropriate to then utilize the sort of the constitutive definition of wild animals used by Palmer then, in order to address this matter that we've just discussed?
Sorry, used by
So the constitutive wildness refers to rather a spectrum, and on that spectrum, wild animals are animals that are not domesticated. So that is the distinction used. So it is moving away from ownership, but considering the fact of domestication, rather, in order to expand the protection to wild animals.
Right. Yeah, I mean, I think that could be an option. I think that could be then within a certain jurisdiction, that could be how they define it. I do think also domestication has issues, the definition of domestication, and also whether it's on the species level or the individual level, or captive wild animals in zoos, for instance. So I think you will always find like certain gray zone areas that you would have to then deal with, regardless of the definition.
Thank you. That is the complexity of the process, and the issue obviously is to find these definitions which can stand the test of time. So also in terms of the more generic issues, you've unearthed and inaugurated wild animal law. And so my one question when I read about that proposal immediately was, and I think you've also referred to the subdisciplines of environmental and animal law. So it's sort of in between those subdisciplines. But just considering the current legal architecture and the normative framework, how does wild animal law relate to, for instance, international wildlife law as a subcategory of international environmental law and as a subcategory of international law? So that's the one thing. And the second question that I have is, how does that relate to this whole project of global animal law, or GAL?
Right, thanks. Those are great questions. I think I will address the latter one first. So I think indeed wild animal law, I applied to the European regime. I took Europe as my jurisdictional scope, but I do think similar analysis are possible in other jurisdictions as well as internationally, although I think internationally a lot of work has been done already by those scholars that look at international environmental law and animal welfare, like so yourself. But I would say that concerning global animal law, wild animal law is and should be a subset of that. It should be completely integrated into global animal law. I think this first wave of animal law, like a lot of the initial work on animal law scholarship, has neglected wildlife a lot, and there should definitely be a call to integrate that further. In terms of international environmental law and international law more broadly, I think that wild animal law as an area of law would already be best developed maybe there, although I think the integration of animal welfare is still lacking, like the recognition of animal welfare also as a general principle of international law is of course still very much underway, but there are many proposals to that matter also within the Sustainable Development Goals, etc. So I think wild animal law has been already maybe to some extent inaugurated within international environmental law. Thanks.
Thank you, that sounds sensible. To move on to the next question that I have, it's on page 5. And there you also, and I'm referring now to an introduction which provides the cornerstones or summation of the cornerstones of your ideas. And the one thing that you mentioned there, and that's also in terms of biodiversity dogma, is it's to argue that conservation law does not protect biodiversity, but regulate sustainable use of its components. Now, I think that is a given in the current context. Have you considered that the meaning and sort of the historical development, progressive development of the concept of conservation vis-à-vis protection. And when I refer to this, it is what I always refer to as a can of peaches. It's like a can of peaches. You conserve something and you preserve it, but it's for your own use. And so conservation law is indeed essentially about how can we as humans use what is referred to in the CBD as biological resources. Essentially, in terms of international wildlife law, it deals with natural resources and not, it doesn't actually refer to sentient beings, which is the scientific fact. So it is about the issue of sustainable use of the components of biological diversity. And that is I think that is a given. So have you considered also the fact that there was an understanding of conservation as something with a stronger ethical component, and that was referred to essentially as protection. So protection not only for the sake of ensuring that we have a certain whale stock in terms of the International Whaling Convention, but also a recognition of some form of intrinsic value of the species and the individual components, constitutive components of the species. So I think that is the one issue here. That is, I think, a given that is also accepted by scholars. That's the one issue in terms of that. But then the second issue is, does that sustainable use not potentially provide certain, what I refer to as hooks, and maybe in terms of your metaphor, spades for digging further, in order to unearth something more ethical to pursue protection? And there I refer to the ethical and humane use components. I'm just wondering, the fact that, it does not protect biodiversity, I think that is a given. Conservation is about human beings. How can we essentially, if I can put it in a very crude manner, save something so that we can use it later, so that we don't, deplete every single whale that exists? And how does it actually then strengthen your arguments in terms of the thesis?
Right. Thank you. I agree with you that it's a given, of course. But at the same time, if you look at a lot of different legal scholarship on this matter, I think especially the fact that the CBD, for instance, the preamble recognizes the intrinsic value of biodiversity, it's often used as a hook to say that biodiversity needs to be protected or needs to be conserved, regardless of its use for humans. So these are like literal citations that I also refer to in the literature review on intrinsic value that are used by scholars to say that, so therefore biodiversity should be protected, regardless of the use for humans. So there is, even though indeed you find often this recognition, like of course conservation is about use, of course it's about sustainable use, but at the same time there's this idea of, but the law also recognizes the intrinsic value, so there's also this big non-anthropocentric element that's very, very important. So I think what I try to just make as explicit as possible is that regardless of that intrinsic value, that doesn't mean anything. If anything, it just further substantiates indeed this sustainable use aspect. And with regards to the conservation and protection elements, as these are two different things maybe, I think indeed in the history of conservation, there was also often this concept of preservation that was very quickly shedded again in favor of conservation, because conservation includes the use of the components, and preservation maybe not so much. But I think in terms of protection, I don't think it's necessarily that different from conservation. I think protection would only apply. So I think, for instance, you could say that conservation consists of three different phases. So the first phase is protection. So this is in the case of very rare species that cannot be used because it cannot be done sustainably. These are protected. Then the second phase, if we have enough of them, then we enter the sustainable use phase. So these species, these components can be used until the limits of sustainability. And then the final phase is if we have so many of them that we actually think there are too many, and then you enter the management phase. So then we start culling animals or plants to bring down their species numbers. So I don't, in that sense, maybe you could say that protection is different from conservation, but I wouldn't say that, for instance, if a legal instrument refers to protection as opposed to conservation, I wouldn't immediately draw too many conclusions from that, because I would kind of think that the rules and the principles in the instrument would still be the same.
That's interesting. I would like to just revert to your reference to intrinsic value, because, you know, for me it was always been very interesting, that reference to intrinsic value in the preamble of the CBD, because it was the first time it was mentioned. You do have another regional instrument in the African Union that has a similar reference, but it's quite interesting. Would it be possible then to argue, in terms of what you've said, that there's a sort of a binary, sort of a contradiction in terms, if I may use that word? Because essentially the preamble of the CBD refers to not the intrinsic value of biodiversity. It doesn't refer to that. It refers to the intrinsic value of the conservation of biodiversity. And so the question would be, if one takes cognizance of what you've just mentioned, would it be possible to state that there's essentially conservation as we know it is very much about, you know, usage and essentially exploitation, can of beaches. But then you have the issue of intrinsic and linking those two, because intrinsic value it's in itself for itself. And you've done, you know, you've really traversed the scholarship on intrinsic value, course card and so forth, really provided a very comprehensive analysis of the aspect. But a very crude approach has always been just to state it's in itself for itself. That is it. That's very crude. Mm-hmm. But if you take that view, is it not essentially a contradiction in terms? Because you have conservation, which is about using, and then you have intrinsic value, which, and you, in your thesis, you also refer to intrinsic, extrinsic, final, instrumental. And I think these things there's also some overlap, and I think you recognize that as well. But if you take that view, are we talking about a potential contradiction in terms in the preamble of the CBD? That's one thing that I was just thinking about when you mentioned it. The second thing is obviously, I think, to take cognizance of the fact that it's possible, obviously, to argue that the conservation of biological diversity, because we're talking about biological resources, that implies that we can talk about intrinsic link to those resources. And so if you take that argument, on the other hand, you may indicate that there is a sort of a change, a paradigm shift, because in terms of the Vienna Convention on the Law of Treaties of 1969, an interpretation of preamble means that you refer to the reasons for the conclusion of the instrument. So you have those reasons. So it means it's like motive. You can't talk about state motive, but it's nearly like motive. And is it not then possible to argue that that was sort of one of the reasons in addition to other values? But if you read the provisions of the CBD, it's what you would refer to potentially as extrinsic or instrumental. And so that there's on the one hand, the question is whether there's a contradiction in terms. On the other hand, there's a question whether maybe it's the, you know, sort of the reason why it was concluded, but you've not really developed that, and it doesn't reflect that in the provisions. And I'll ask a third question, but I'm going to stop now and give you a chance to respond.
Right. Yeah, thank you. So I do think, indeed, it is a contradiction in terms, and I would really like to go back in time and be at these negotiations and see how this term found its way into the preamble, because I wonder if they knew back then that if they just wrote this down, that it would have this effect that like all these legal scholars would just use this little hook of intrinsic value for years to come. But I think it essentially indeed builds upon this these conflations of intrinsic value that are done in environmental ethics, and that Korsgaard points out in her work indeed. So maybe it was like some environmental ethicist who was at these negotiations who tried to get it in there, I'm not sure. And I kind of forgot your other... I forgot your other question.
I think I've also forgotten it, to be honest. I was just talking and talking. No, so the second question is, and maybe I can ask a second question in relation to another aspect. The second question was, so intrinsic value, being a certain value embodied in the preamble. Is it not then possible also to argue, yes, so it was embodied in order to provide for that, something different than extrinsic, and something different maybe than mere instrumental value. So something that's intrinsic, final, in itself, for itself. So that was indeed the sort of, I use this word with, abundance caution, that was indeed the motive of states. But that it was not really reflected in the provisions per se, but that does not necessarily in terms of a logical argument mean that it does not exist, and therefore it could serve as a so-called, what I refer to as a hook. Glimmers, what I always refer to these things as glimmers of hope, because we need hope in this current world. And therefore, if you link that argument then to decision 7 of the COP CBD on sustainable use, all of a sudden you unearth this reference to not only intrinsic value, but also ethical and humane use. And if you then follow the Vienna Convention law of treaties concerning the interpretation of decisions, maybe that's sort of the and I'll use a metaphor here. If you make wine, then you use yeast. And so maybe that was the yeast that was actually injected into the product in order then to ensure that there's a fermentation to a product. And what we essentially need is to go through that wine-making process. But we've been provided those scant opportunities in order for this crystallization into something that is more ethical and humane. And so therefore, that would be my question, if it makes sense.
Yes.
And apologies for the reference to winemaking.
No worries. Yeah, thank you. So indeed, I think this is one avenue to walk. Exactly, you can use the intrinsic value as a hook, and you can use these decisions on the ethical use of the components of biodiversity. But what I did in my PhD was not really look for these glimmers of hope per se in the law as it stands. I was really just analyzing to see what legal rules and legal principles we can derive from it. And looking at these legal rules and principles of conservation law, like you also say, you do not find this idea of intrinsic value. And moreover, because of this warped kind of idea of biodiversity, there's really nothing like non-anthropocentric about it. So then I just did this analysis, and then in the final part, where I guess you could say did build further avenues, I just went a completely different approach. Instead of trying to find hooks in the law as it exists, I just built a lex ferenda, law as it should be, framework from the ground up, essentially.
Thank you. That answers my question. In terms of what you've just mentioned, you've mentioned non-anthropocentric. So it's sort of a very non-anthropocentric approach in terms of the CBD. But you then refer to this concept of prudent anthropocentrism as well in your thesis, which I read with considerable interest. That prudent anthropocentrism, is it not merely sort of a description of what I've referred to as enlightened anthropocentrism? So it's anthropocentrism, but it's an enlightened form. But we also, and just to continue in terms of this argument, we can establish, or we can see once again those glimmers of hope in terms of enlightened anthropocentrism via reference to intrinsic. Yes, it's what I refer to as decorative. It looks good, and when you read it, you become all excited. But then there's nothing. There's no substance when you review the provisions. So is that not essentially the same thing? And can't you use these glimmers of hope in order to identify that there is indeed a potential move towards enlightened or prudent anthropocentrism? We can use other terms as well. Yes.
Yeah, thank you. I think that's exactly indeed the case. I think also within environmental ethics scholarship, prudent anthropocentrism and enlightened anthropocentrism are often used interchangeably. So yes, absolutely. I think what I just tried to do was make these things explicit, and I think indeed, as you say, what also is kind of how cynical anthropocentrism is defined, this idea of like that we have an anthropocentric reason to be non-anthropocentric in our day-to-day thinking. I think that is exactly what this preamble tries to do. It tries to present maybe this like non-anthropocentric reason, even though of course the ultimate reason is anthropocentric. And what I just aim for is to make these things explicit so that then indeed perhaps scholarship can then find maybe more glimmers of hope in the law as it stands, because it will be more clear, hopefully.
Thank you for that. So also in the vein of that prudent anthropocentrism, you refer in the thesis also to the right not to become extinct, and you refer to the scholarship of Ralston in this regard as well. But you sort of use that as an example also of this cynical form of anthropocentrism, because this whole concept of not becoming extinct is only that very crude anthropocentric approach to conservation. It's for humans. I'm just wondering whether that is correct in the sense that would it not be possible to distill a sort of a right or entitlement on the basis of international wildlife law of animals not to become extinct? And that, yes, that right could potentially, as in first instance, serve humankind. But there's also the other component, if you don't die, that you may serve your own interests. So as an individual animal, the fact that species don't become extinct mean that you also need to sort of focus on the bees and not only the hive, so the elements, the individual animals. So in that sense, is there not a possibility to speak in terms of international environmental law of a right not to become extinct that is not merely anthropocentric, but essentially really this prudent or enlightened form of anthropocentrism?
Right, yeah. I mean, I think indeed you could say that you can maybe even say that there is already this right not to go extinct in international conservation law, depending on, of course, how you look at rights from like a Hofeldian perspective. But I don't think that this is ultimately has anything to do with the individuals themselves. I don't know, I don't see how there could be like an intrinsic value as a species, for a species. And I think this is also not reflected at all in biodiversity law. So for instance, wolves and dogs, for instance, let's take these as an example. So wolves are, until, of course, very recently, were very strictly protected in the EU. They're still protected in a lot of places globally as a vulnerable or rare species. And dogs, of course, are not. They are companion animals. We have a lot of them. But they can reproduce, and their offspring can also reproduce. So in a sense, they are like, according to a biological concept of species, they are the same species. So the right not to go extinct does not then only belong to wolves or only to dogs. It should belong to all of them. But we make these distinctions in conservation law to say, no, we want wolves and we want the genetic purity of wolves only, and then they would have like the right not to go extinct as a species, but they cannot reproduce with dogs. And then I don't see how that would in any way connect to the intrinsic value of a species, because they can reproduce as a species. They can keep existing also through, for instance, hybridation between these two. So I think in essence, like in theory, this idea of the right not to go extinct could exist, but then our whole idea of biodiversity and species also would have to change to go along with that.
Thank you for that. Just to drill deeper into the detail of the CBD further, you've referred to, or on page 46, you have an analysis of the CBD, but you also said it's not a real conservation agreement because it does not include a listing mechanism. I was quite intrigued about that statement because the CBD is an umbrella agreement, a framework agreement in terms of the definition of the Vienna Convention on Law of Treaties. So I was quite interested in that reference that you've made there. And then you go on in terms of page 46, and you refer to a second issue that I found quite interesting. The confirmation of sovereignty resulted in doubt of the weight of the CBD. So those two arguments seem to erode the legal status, value, and contributions of the CBD. And I was quite intrigued by that because, in my mind, the CBD is a conservation agreement in terms of my understanding of conservation and also my understanding of the issue of international agreements. But the second thing is the fact that you've included sovereignty. Sovereignty is a legal principle, permanent sovereignty over natural resources and permanent sovereignty of peoples over natural resources. So it is recognized as one of the primary and fundamental principles of international environmental law. And so my question is, how will that actually erode the CBD? Or is it rather possible to argue in a different manner, for instance, and to argue for a form of sovereignty by reference to the common concern of humankind, which is quite interesting. And the common concern of humankind results in a globalization of natural resources, not the common heritage of mankind, which is very different. Mm-hmm. So that, and the globalization of resources, would that not be a hook in order to argue for the globalization of welfare? And in that sense, yes, indeed, sovereignty is referred to in the preambular paragraph of the CBD and in the provisions, but it's nearly as if you couldn't have done anything else because of the fact that it's a primary legal principle of law. But then common concern, I think, erodes maybe that very crude, sort of rigid approach of that form of sovereignty, and one could potentially use that as a hook as well. I don't know what your views are on that.
Right, yeah, thank you. Yeah, so indeed, I wouldn't say that the CBD is not an international agreement or anything like this. It is, of course, just a treaty following the law of the treaties and all that. But I will say that if you look at the phrasing and the objectives and the purpose, it does appear very much like a framework agreement. And also, it was adopted, of course, at the same time as the United Nations Framework Convention on Climate Change. And I think it's very visible that there was like a similar idea. So we're going to do the Framework Convention on Climate Change and then the Framework Convention on Biodiversity. And also in, for instance, the commentaries on the CBD that were adopted at the same time, there's also this repetition of it is, in a way, a framework convention. And that's then just what I used in order to say that's why the CBD doesn't have this listing mechanism, because I very much built on this listing mechanism as like a very defining feature of conservation law, and the CBD doesn't have it. It was almost having it, there was a provision on lists of both habitats and species, I think, but this one was deleted at the end to kind of also, I think, further erode like the whole strength of the convention as a whole. So that's why I went to that argument of saying that because it kind of functions as a framework agreement more than anything else, it doesn't have this listing mechanism, but that does not erode my argument of that feature, basically. And in terms of the intrinsic value and ethical use.
The second question was more about the fact that the reference to permanent sovereignty.
Right.
And then the fact, what could one not make the argument because of the inclusion of common concern? So it's quite an opposition. You have common concern, you have permanent sovereignty, and they seem to be contradicting each other. And so I've made the argument, for instance, that there is a possibility to argue for the globalization of welfare because of the fact that common concern globalizes natural resources, and permanent sovereignty is about it has its strands and history in the 60s, the new international economic order. So it was contextually in terms of the interpretation thereof. But we've moved on beyond that. We're now 2025, yes. So I had to think for a second. And so there's a major paradigm shift from there. And I think this could be a potential hook in the CBD to make that argument that, yes, permanent sovereignty is problematic due to the fact that it refers to exploitation of natural resources, essentially, and animals are considered, wild animals, as natural resources. But there's also that other avenue that could be used in the concept of intrinsic and common concern.
Right, yeah, absolutely. And I think I had a whole section on the permanent sovereignty of natural resources as a principle, and how I think I also argued that it wasn't really maybe perhaps even meant for wildlife as resources because it was so focused on minerals and like the independence wave and everything that was happening back then. And now you see like kind of this tension in the CBD, of course, between this principle and the common concern. And I think indeed there are hooks there that we can build upon to say that they should be like united. But ultimately, because I focused more on the European regime, I deleted that section, which I'm now regretting.
I think that's very sensible. It makes sense. And I wondered about that aspect, but I think you've addressed that now. And I do think you sometimes need to remove sections and components of your work. You can't address everything. It's very comprehensive and all-inclusive. It's not possible to address all these issues, obviously. You need to be concise as well. I would actually like to move to maybe ask you a controversial question. It's a question that I have in terms of animal agency. And I'm not going to exhibit the fact that I agree or support or even underwrite this, and that's why I think it's extremely controversial in the sense that it may even be nonsensical to an extent. But I'm going to ask it anyway, because I'm allowed to do that. So the question that I have is in terms of animal agency, and that is also a very interesting part of your discussion and one of the cornerstones of moving towards your proposal. And so you've traversed and navigated through different possibilities and opportunities, such as rights and so forth, and then dealt with animal agency. Do you perceive the possibility of moving towards a position via animal agency where we could conceive of not only entitlements of animals, but also obligations? So obligations of wild animals towards the habitat, ecosystem, other animals, humans. Could you expand that to move towards issues concerning human-wildlife conflict, for instance?
Right, thank you. Yeah, so I think what I try to do is really discuss like the legal framework aiming to protect animal agency, so protect their autonomy and their right, you could say, to self-determination. But then there is, of course, also this whole like growing body of scholarship regarding animal agency in the law. So animals as legal agents, making decisions, having legal competences, etc. And I think indeed following that avenue, you could say that they have duties as well, have obligations as well. And then I think this opens up a lot of like very fascinating possibilities to also think of co-constituting the law with animals as agents, and then design the law in a way that these obligations would be clear and would be phrased in a way also for indeed, for instance, human-wildlife conflict. Absolutely.
Don't you think that opens up the possibility for sort of an excuse for people to actually validate overexploitation via reference to the fact that, certain animals now have responsibilities or obligations, they're not complying with it, and therefore, you may punish them or do something. And the interesting thing is obviously in terms of, as you know, the history of, especially in the UK, we've had various cases against individual animals, criminal law cases. And so it's not totally ludicrous and unthinkable, because it did occur. So I'm just wondering whether that's a potential danger of that sort of argument.
Right, yeah, maybe it is indeed. I would also say that the rule of law would also still exist, and if an animal would, I don't know, like go on your property, I don't know if the rule of law would then allow it to say it, broke its obligations and now we can kill it. But I also think that it's worth trying and thinking about anyways, because there is not such a big difference between what is happening right now with animal exploitation as well. So I do think even though there might be risks like this, indeed, there's still plenty of reason to theorize about these kind of frameworks.
Thank you. That's interesting. I would like to turn to the issue of intervention. in relation to wild animals, and you've discussed the hands-off approach and sort of the complexities with that initial sort of traditional dogma that, for instance, some of the Reagan, for instance, referred to the hands-off approach initially. And clearly that's not a very satisfactory approach, as we know. But it's also a very complex issue in terms of the current scholarship that you have in environmental ethics, where you have a call for absolute intervention, the ending of predation, and so forth. And so my question here would be, well, I have a few questions, but let me start with the first question. I've considered this issue, for instance, to give you an example of the issue of predation. Do you think maybe, and this is, I think this is an unfair question even, but, and there's no right or wrong answer. It's something that I've actually, sort of reflected upon quite recently. Do you think that sort of some of these proposals to end predation, to intervene in all aspects of wild animals in order to ensure, with positive obligations, to ensure that wild animals do not suffer, do you think that that maybe is based on a disconnect with nature and a misunderstanding of nature, because we as Western humans have that sort of disconnect with nature? I cannot recall the last time when I saw, a lion walking in the street. So we don't have that connection with nature anymore due to the Anthropocene. And so we also don't fully understand the complexities of the biosphere. And, to take it further, and this is my third question, it's maybe philosophical, but I've reflected on this. The whole sort of concept of avoiding and evading death, to me, seems to be part of that, because death is an unnatural thing. And so we've moved away, and I'll exhibit the Stoic in me, from the concept of mero mortu. So that death is part of life, and it is awaiting us. Don't you think that's some of those aspects have actually resulted in a distortion of an understanding of the complexities and intricacies of nature? And that essentially through that approach, we are trying to manage something, and essentially what we're doing, that is an imposition of the most anthropocentric approach that you can think of, and that is to without any sufficient knowledge, try to manage the cycles of life and death in nature. So just a very philosophical question.
Yeah, thank you. I mean, there's a lot there, I think. I don't know if this intervention approach, as it has become kind of established in wildlife ethics, I'm not sure if it came from this disconnect with nature, or also, I mean, I do think that life in the wild, like the violence of it maybe is also glamorized in a lot of ways, like in wildlife documentaries, this is often the focus, because I think that's kind of like the interesting things also maybe that wild animals do are related to suffering. So these are the things that we also then always perceive maybe. But either way, I would say indeed, like it's completely managing and controlling life aspects of wild animals. Like there's no way that interventions would be possible under, like, for instance, the agency framework. There's no more control that an animal would have over their own life. As opposed to like the connection to death, I'm not sure if the intervention approach is this. I mean, I also have read, for instance, that veganism is also an element of trying to distance ourselves from death. So you can also, I think there are many ways maybe in which we look at nature and culture ourselves and this issue of death maybe.
I think it is a complex issue, but I have reflected on it. And it's also because initially I referred to the disconnect as one of the indirect drivers for extinction, as mentioned in the IPBES. And I think it does warrant reflection. I don't have a specific answer concerning the matter. I think I have time for one or two more questions. So I just wanted to ask you, in the vein of referring to death and killing and all those aspects that you've mentioned, I was wondering, you've also referred to hunting as an exploitative action. And my question there is, once again, how are there different forms of hunting? What are there, so in terms of wild animals, do we consider all forms of hunting to be exploitative, or should we actually move towards a process of preventing all forms of hunting? The reason why I'm asking this is there are different forms of hunting, obviously. You have trophy hunting is one example, so-called therapeutic hunting. And now I don't agree with I've never shot anyone or anything, but that is a subjective issue, obviously. The question is, are there different forms of hunting? I can give you one example. The indigenous people, the Khoi and the San, or specifically the San, they really, they've walked here 6,000 years, 70,000 years ago, some of the oldest people on the earth. They've had a very specific relationship in relation to their prey and the way in which they've actually killed the prey, but also consumed the prey, which differs considerably from an issue such as trophy hunting. So I was wondering about that you had made that reference to hunting, and I was actually considering the fact that, yes, you may have different forms of hunting. And how does that relate to your view and appraisal of that activity?
Right, yeah, thank you for that question. Indeed, I think that's also one of the appeals, I think, for me for this idea of agency and the agency framework as opposed to rights. So with this idea of wild animal rights, for instance, you could say that an animal has the right not to be hunted, and it would be very universalized. It's this liberal idea, of course, of a right, which doesn't then allow, indeed, for nuances. And I think, for instance, with this idea of animal agency and also these principles of coexistence, for instance, does allow also for communities where humans and animals live, where, for instance, indigenous hunting takes place. I do think that there is space for these kind of nuances and these kind of contexts within the framework, as opposed to rights. So absolutely, I think that there are different forms of hunting, and it just depends on the context. Like localized rules should then inform whether, for instance, trophy hunting. I don't know a lot about like the way that whether it helps local communities, for instance, or not, or whether there are also different ways then that can be thought of like wildlife tourism that would also do the same thing without the killing. But indigenous hunting would definitely be one of the ways where you could say coexistence also means that in this particular context.
Thank you for that. You've referred to rights, and so I'd like to address the issue of rights. And on page 139, you refer to, so it was interesting the issue of international wildlife rights that I've written about, and you challenged that theory, which I found quite interesting. So I couldn't help but to challenge your challenge to respond to the gauntlet being thrown down, because on page 139, you mentioned that there's an assumption that all eradication of species aimed at prevention of extinction forms the backbone of this, this issue concerning the theory on international wild animal rights. And then you indicate that it's not always about the eradication of species in terms of the prevention of extinction, and that's the focus, which is you're absolutely correct, obviously, there. But it's not that, and then you use the example of biotic homogenization as an example, that eradication is not always aimed at species extinction, which is also correct. And now it seems like I'm affirming everything that you've said. But it is aimed at the prevention of biodiversity loss and the understanding of the issue, the three concepts of homogenization. And I think the three concepts, so it's important to understand the three concepts of homogenization, which is taxonomic homogenizations. These are the elements underlying biotic homogenization. So that taxonomic homogenization is where you have an increase in similar species across different regions due to replacement of native species with non-native species. So it's a replacement approach that is followed there, or invasive species. But you also have the functional homogenization, where the ecological roles of functions of species within a community become quite similar. And then that leads to a loss of specialized species with, who actually keystone species fill certain unique niches in terms of the ecosystem. And that then once again has an impact on the issue of the loss of species. So it's extinction once again. And the third component or element of biotic homogenization is genetic homogenization. And that is the reduction of genetic diversity within populations. And that's where you also have the hybridization, you've referred to that, of non-native species or the loss of local adaptations. So those are the three elements. But if you sort of analyze and assess the causes for those three elements underlying biotic homogenization, you'll see that it is essentially extinctions of native species that you have. So that's the major issue, the loss of native species due to habitat destruction, climate change, all sorts of other anthropogenic pressures, which results in a decline of biodiversity. And that is essentially the issue here. So that's the one aspect, and then there's also the invasions of non-native species. So we have an introduction of non-native species. But all these things essentially lead to extinction. And so the issue there is read with Article 8H of the CBD. If you read that, it refers to the broad obligation to prevent the introduction, control, or eradication of alien species which threaten ecosystems, habitats, or species. So biotic homogenization is a broad concept, but it's related to the issue of extinction. And so therefore the question is, I think it was on page 139, if I'm not mistaken, there's somewhere, maybe I'm incorrect. So my question essentially, so it is, that's right. So if you focus on that objection, does that then refute the possibility to utilize the rights approach in order to reconcile what I've referred to as holism and individualism through a rights approach? Because essentially the objective would be then to reconcile that with Article 8H. And so, yes, biotic homogenization is a component, but it has different elements and underlying causes, which will essentially, all of it boils down to extinction of species. And then the question is, does that then refute the possibility to use rights? And that's a possibility. It's not to say that it should be used, but it's just about a theoretical possibility based on the fact that you currently have sort of a plethora of domestic jurisdictions promulgating these rights. That's the, I hope it made sense, the question
Yes.
that I asked, which was hidden there somewhere.
Yes. Yeah. I mean, I think a lot of what you said comes down to this biodiversity dogma, basically. So indeed, I think these three layers that you describe, they are, you could say, maybe biodiversity as you see it in conservation sciences, and it can be measured in a lot of different ways. So you can look at species diversity in an area, or species complementary, which is like one area compared to another, or species uniqueness. So there's all these different tools, I guess you could say, or different models. And what we then see in the law is that there's basically only one model that has found its way into the legal regulations, which is the model of uniqueness, so the model of rare species. So I don't think it's accurate to say that biodiversity as like a concept is only species extinction. I think it's a lot more, and it can be measured in a lot of different ways. And indeed, invasive species can affect rare species. It can also lead to species extinctions. But to have this blanket statement of invasive species are always a threat to biodiversity, without taking these different nuances into account, I don't think does justice to like the realities of nature and all its complexities. And you also see that, for instance, an animal species that is listed on the invasive alien species list by the EU is threatened in its own home country. So it's an invasive species in the EU. It's like there's ideas to eradicate it because of this, but where it's from in its home range, it's also threatened due to habitat loss or other issues. So in terms of like overall diversity of species, it's odd to me that then this species should be eradicated in both and ultimately then might become extinct. So I don't want to suggest that invasive species are always good by default and they should be embraced everywhere. But I do think that there are nuances that should be made and that the context is just always really important, including then also the question, okay, what is exactly being threatened and why? So also with for instance, the grey and the red squirrels in the UK, like what is exactly happening? Are these red squirrels only being threatened because of the grey squirrels, or is there also a history of red squirrels being defined as a pest to the timber industry and being managed there, and what will happen if we do get rid of grey squirrels? So I think there's just a lot more into the question than what you see now in the law, and especially in European Union law and from the Council of Europe, there's also this idea that that alien species should be considered guilty until proven innocent. So then you have already a whole mound of species that are managed as a threat, even though they might not be. So I think the main idea is that there should just be a lot of nuances, both in the concept of biodiversity and in the threat of invasive alien species.
Thank you for that comprehensive response to a comprehensive question, Madam Candidate. Mm-hmm. It is with that I've now exhausted all of my questions. Mm-hmm. So, in response to the examination or the questions that I've actually asked, I would just like to present my sort of concluding statement, final statement concerning the matter of your PhD. So, when I assessed both the written work and also your responses verbally, I utilized a certain framework in order to appraise your performance, Madam Candidate. And the first one is very important, is significance. I've already, to an extent, I think, hinted or referred to aspects of significance in the opening statement, but I would like to refer to some other aspects as well, in addition to the references that I've actually made already. I focused very much on the need for a transformative sort of action to be taken, meaning a transformative contribution through the dissertation itself. I've read this with significant interest and found that quite clearly there is considerable significance in the dissertation as it contributes broadly to various aspects of scholarship and the law. Animal law, the issue of international environmental law, international wildlife law, but not only in relation to those aspects defined as law, those areas defined as law. I think it's also the fact that you've used this ethical analysis, so ethical in conjunction with the legal analysis, and made it quite interesting in terms of significance, because it means that in terms of significance, you're also able to contribute to the issue of environmental ethics and animal ethics. And also sort of in that linear progression towards, from the divorce of ethics and welfare, or environmental ethics and welfare, towards maybe mediation and reconciliation. And I think in terms of that debate, this work is really significant. So it is significant in its contributions there. In terms of originality, I found this to be a very, highly original piece of work. I've not read anything similar. The originality lies in terms of both the approach that you followed, the scaffolding of arguments concerning the identification of an issue through a very critical lens, and I think that was quite interesting. And then also original in terms of the results. So in terms of digging, those tunnels to create a habitat for what you propose then as wild animal law. So that is, it clearly serves as evidence of the originality of the result of your research. I think it's also, maybe just to go back to something that overlaps between significance and originality, I think is the way in which you've called for the development of law, de lege ferenda. So I think it's with a thesis, it is always important to ensure that you're able to have some idealism and maybe, a bit of a vision. And I think you've clearly exhibited and presented a clear vision of what ought to be based on what is currently and the shortcomings that we face in terms of law. And through that also contributing, I think, very clearly in terms of regionality to the debates about the issues and sometimes opposing camps of environmentalists in terms of conservation and welfarists. So bridging the gap between both of them in a very original and significant manner by taking cognizance of the interplay between welfare and conservation issues and the underlying ethics. So I think, in terms of that component of regionality and significance, you've really contributed to burgeoning scholarship, which has really developed significantly the past 8-9 years, maybe more or less. I recall the current edition of Bernie Boyle-Rechwell on international environmental law, which is the foremost, I consider to be the foremost textbook on the subject field. And in that textbook, they rightly referred to the issue of wild animal welfare as being on the fringes. And it's a very apt description. But I think it has changed, and you are also one of the agents of change, which is a very positive aspect. In 2010, the pivotal work on international wildlife law, the Lister's International Wildlife Law, for the first time included a chapter on wild animal welfare. And so that was a glimmer of hope and a hook that you clearly pursued in your work in order to contribute to the progressive development of the subject field in a very significant and very original manner. In terms of the rigor of the scholarship and the rigor of your research, I have a few comments that I would like to make as well. So when I read the thesis, I was really impressed by the way in which you handled and cited scholarship, not only in terms of legal scholarship and sources of law, but as I've said, also in terms of sometimes difficult publications of animal welfare ethics as well as environmental ethics. So you've really utilized authoritative publications in a very skilled manner, but not merely in a descriptive manner, but being able to distill your own original concepts in a significant manner as well. And that is really important for a PhD. So not only being able to do the research, but also to do it in an independent manner, and from that distill these concepts. And that was really, you've provided sufficient evidence in your book of that skill. The other thing that I really found impressive was the fact that you've in a very structured, logical manner, you've provided your central arguments based on premises and hypotheses. And you've then clearly use a scaffolding process of building your central arguments towards a coda, the conclusion, which was then the delivery of the concept of wild animal law as an original contribution to scholarship in this regard. And it's only possible to do that through an exhibition of skills and expertise as an independent researcher, and obviously also use your expertise. You've done that in a manner which was impressive, clear, concise, original, significant, but also through the utilization of language and grammar, which was very clear and which clearly met the highest standards. So, what does that all mean after I've now provided you with this Lodé? What does it all mean? Essentially, it means that I found this to be a really impressive, well-researched, thoughtful, and comprehensive original dissertation and an original contribution to current scholarship. It displays your research skills and intellect as an independent researcher. And with that, I would like to congratulate you on an excellent product, as well as your supervisor, who's here today. Congratulations to both of you as well. And it was an absolute honor for me to act as your opponent and to have read this. And I wish you all the best on your journey forward. And with that, I would like to propose, and I will propose this to the Faculty of Law, let me say that, not only I will, that the dissertation be accepted. Thank you.
Thank you, honored opponents. If anyone present wishes to make any comments concerning my dissertation, please ask the custos for the floor.
I see no hands, so I declare this public examination concluded. Coffee and cake will be served right outside in the foyer, and you will also have the opportunity to congratulate Dr. Veerle Platvoet there. And this proceedings are concluded, and we will now proceed to the foyer.